Good morning, friends. Now, today I will discuss with you latest guidelines on arrests and bail orders. Recently, the Supreme Court of India in Stender Kumar Antil versus CBI laid down fresh guidelines on arrests in order to have strict compliance with the provisions of Section 41 and 41A of CRPC 1973. The bench further said that the courts will have to certify themselves on the compliance of Section 41 and 41A. Any non-compliance would entitle the accused for grant of bail. The court has also emphasized upon separate legislation on the law relating to bail and concerns of delay in bail and the plight of under trial. The court in a recent judgment linked the idea of there should be bail, not jail. Now, talking about section 41 and 41A of the CRPC, what these sections say? Section 41 of the CRPC provides for circumstances in which arrest can be made by the police without a warrant and mandates for reason to be recorded in writing for every arrest and non-arrest. As far as Section 41A of the CRPC is concerned, it provides for the requirement of a notice to be sent by the investigating agency before making an arrest in certain conditions prescribed by the court. Now, if we talk of bail, CRPC does not define the word bail. We can say bail refers to temporary release of the accused person awaiting trial, sometimes on the condition of a sum of money is granted for their appearance in court. If we go by the IPC, it categorizes bailable and non-bailable offences. CRPC empowers magistrates to grant bail for bailable offences as a matter of right. And in non-bailable offences are cognizable, which enables the police to arrest without a warrant, and magistrate in such cases would determine if the accused is fit to be released on bail. In our Indian culture, there are various types of bail. One is regular bail, which is generally granted to a person who has been arrested or is in police custody. Then comes interim bail. This type of bail is granted for a short period of time and it is granted before the hearing for the grant of regular bail or anticipatory bail. And third type is anticipatory bail. It is granted either by the session court or high court. An application for the grant of anticipatory bail can be filed by the person who discerns that he may be arrested by the police for non-bailable offences. Now, coming to Supreme Court's earlier observation related to arrest. First verdict was Joginder Kumar versus State of UP in 1994. The court has stated that the arrest and detention in police lookup of a person can cause incalculable harm to the reputation and self-esteem of a person. And in Arnesh Kumar versus State of Bihar, that is of 2014, an honorable apex court observed that arrest brings humiliation, curtails freedom, and causes scar forever. And in Satinder Kumar, what the court said, In Satinder Kumar Antil versus CBI, that is of 2022, the court issued specific directions and has also called for compliance report related to Section 41 and 41A of the CRPC. Now coming to latest Supreme Court guidelines with respect to bail. Firstly, the Honorable Court said that there should be a specific legislation. Court pointed out that Government of India may consider the introduction of a separate enactment in the nature of a bail act so as to streamline the grant of bails. If we talk about UK Bail Act of 1976, it prescribes the procedure for granting bail and aims to reduce the size of inmate population. The Act recognizes a general right to be granted bail and has provision for ensuring legal aid for defendant. The Act provides specific grounds for rejecting a bail. For instance, defendant on bail would not surrender to custody, would commit an offense while on bail, or would interfere with witnesses, or otherwise obstruct the course of justice. So next, why the bail application. The court held that there need not be any insistence on the bail application while considering the application under certain sections of the code. These sections relate to various stages of trial where a magistrate can decide on release of the accused. The Supreme Court held that in these circumstances, magistrates must routinely consider granting bail without insisting on a separate bail application. Next direction was adhering to timeline. The court clearly directed that bail application ought to be disposed of within a period of 2 weeks, except if the provisions mandate otherwise. The court also held that the application for anticipatory bail are expected to be disposed of within a period of 6 weeks, with the exception of any intervening application. Next direction was compliance with earlier order. The court said that there need to be a strict compliance of the mandate laid out in Siddharth versus State of UP, that is of 2021. And if I talk about what was in Siddharth case, in that case, the court stated that merely because an arrest can be made because it is lawful does not mandate that arrest must be made. The court further stated in the judgment that in case the investigating officer believes that accused will not abscond or disobey the summons, then until and unless he has been charged for a heinous crime, the officer is not compelled to arrest him during the investigation. Then it gives direction to its own honorable high courts. The high courts have been directed by the Honorable Supreme Court to identify under trial prisoners who cannot comply with bail conditions and take appropriate action in light of the section 440 of the CRPC, facilitating their release. Now, what is section 440 CRPC? It talks about amount of bond. The amount of bond shall not be excessive, and high courts and session courts may reduce the amount prescribed by the magistrate or a police officer. A similar exercise has been mandated under section 436A of CRPC, under which a person imprisoned during investigation or trial should be released on bail on completion of half of the jail term prescribed for the offense. It also gave direction to states. The Honorable Supreme Court also directed all state governments and union territories to facilitate standing orders to comply with the orders and avoid indiscriminate arrests. The High Court, in consultation with state governments, will have to undertake an exercise on the need for special courts and vacancies in the position of presiding officer of the special courts will have to be filled up expeditiously. These were the directions so that the jails are not unnecessarily occupied, which can be avoided. It's all about latest judgment directions of the